Welcome to literary and jury charge practice. Let's start with this narrative answer. Ready? Here we go. The meeting lasted a very short time. It was maybe 12 minutes or 15 minutes. We all knew what we were there for. As I said, we had already had all these meetings at a prior date. It was just a matter of finding a good time to have all of us get in the same room. There were only a few key points that had to be talked about. We all soon had a meeting of the minds, and we told Fred Landry to draw it up and that we would sign later. From there we walked out en masse to Alan Henry's office and told Alan everything was great. Then Alan made a number of comments. Well, we left from there and then we went to Fred's office, at which point Charles made a phone call to Matt and told him what had taken place. Fred Landry said, "If you wait, I will draft this up and we can sign it." Charles looked at his watch. In view of the fact that the meeting had taken such a short time, he said he would be able to catch the early evening flight back to Cleveland, and he opted to take that flight. There was some talk regarding about how he would sign it, and Fred said that it was possible to sign a counterpart or something, meaning that Charles could sign his copy and I could sign mine. Then Fred would attach them, and it would be as if we had signed them together. Now let's try a little jury charge. This is a criminal jury charge. Ready? Here we go. Now I want to talk about the kinds of evidence that you have heard in a case such as this. There are two kinds of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is indirect evidence. I mean that it is proof of one or more facts from which one can determine that another fact exists. Statements and arguments of counsel are not evidence in the case. When, however, there is an occurrence where the attorneys on both sides stipulate or agree as to the existence of some fact, then the jury must accept that stipulation and regard that fact as having been proved. Now, in addition, the court may take what is known as judicial notice of certain facts or certain events, and I will tell you shortly about something of which the court has taken judicial notice. You will arrive at your verdict by applying these rules of law to the facts as you determine them to be. It is my duty to explain to you the rules of law that apply to this case. As jurors, you must not be influenced by pity for the defendant or by prejudice against him. You must not be biased against the defendant because he has been arrested for this offense, or because he has been charged with a crime, or because he has been brought to trial. None of the circumstances are evidence of his guilt, and you must not infer or assume from any or all of them that he is more likely to be guilty than innocent. You must not be swayed by mere sentiment or by public opinion or public feeling. You must not be swayed by sympathy or passion. Both the state and the defendant have a right to expect that you will carefully consider and weigh the evidence. Now let's try some literary material. And this literary is called Captioning Conventions, a First Experience. Ready? This past summer, I had the opportunity to work with Jim Connor, RPR, CRR, a phenomenal real-time writer, an experienced reporter of 31 years, and an experienced convention reporter of 30 years. Jim races motorcycles, so I figured he was up for the challenge of captioning for the first time. I asked him to work with me in providing captioning services during an extremely large convention. We were using an AB switch box, which basically means that if Jim were to pass out unexpectedly, I would be there to take over. In essence, training wheels. Jim survived the long day of training, not only on software, but also the differences in writing styles and formats for providing on-site captioning services. Now he is willing to talk about his adventure. I knew his insights would be a valuable tool to others who might be considering captioning. So Jim, now that you've had time to reflect on your first foray into captioning, what are your immediate thoughts of the experience? Looking back on the week of captioning, I thoroughly enjoyed the overall experience. The few weeks leading up to it, I was thinking I'd rather have a root canal. Once I wrapped my brain around the differences in reporting versus captioning at the beginning of that week, I was more able to embrace the task at hand. For a little background, what got you interested in the convention reporting area? My father was a reporter who had done convention reporting since the 1930s. As a result, our firm's convention clientele had grown over the years. My father reported labor union conventions, including the merger convention of the AFL-CIO, as well as the first United Steelworkers of America convention back in 1942. As a newspaper reporter in 1977, I thought this work was what everyone did as part of being a reporter. Here again, even reporting conventions are a different type of reporting, different style, different mentality than everyday reporting. It's kind of fun doing something out of the ordinary. Doing this kind of work has enabled me to work with U.S. presidents, former South African President Nelson Mandela, former Polish President Lech Walesa, as well as members of both houses of Congress. Our convention clients truly appreciate the work we do and the quality transcripts we provide, much like the captioning clientele being appreciative of captioner services. I know it took a little arm twisting for you to agree to now provide captioning during the convention. Has captioning never really been anything you've thought about doing before? I hadn't thought about captioning for television before a full-time gig because I have enjoyed my freelance life of calling my own shots with my time. Now, having captioned for a large convention, I'm thinking I would definitely enjoy that type of work, but hey, my tastes may change as time goes on regarding broadcast captioning. After our day of training, which consisted of learning a slightly different software system, different dictionary entries, and hardware adjustments, what were your initial concerns? My initial concerns didn't involve my dictionary. I feel pretty good about my dictionary because of the real-time reporting that I do. The only concerns were with captioning entries that needed to be input for caption-specific writing, such as the musical notes. The training went very well, I thought, and I felt I picked up on the software differences, but it was nice having your guidance and hand-holding in case I had a brain lapse. Obviously, having someone with your experience made this transition very smooth. After the training, however, there were still some underlying thoughts that maybe this type of work wasn't what I wanted to do. And the first time out of the gate, the minute the AB switch was pointed toward me to take over for a brief instant, I was filled with terror, but the fingers worked just as they always do, albeit a little clammy at first. All right, now for some jury charge. And we will continue on with our jury charge called land recovery. Ready? I charge you that a person who is in possession of land claiming it as his own may rent the land to another and the possession of the tenant under the lease is considered to be the possession of the landlord, so long as the landlord makes claim to the property as the owner thereof. That is what is called the law as to prescription that I have given you. Now I will charge you as to the law of what is called adverse possession. The law as to adverse possession is the means and manner and time by which a person can acquire title to land through adverse possession. Adverse possession cannot confer or defeat title to land unless the party setting it up, that is, claiming through adverse possession, can show that a deed or other color of title purporting to convey title to him has been duly recorded in the office of the judge of probate of the county in which the land lies for 10 years before the commencement of the suit, or unless he and those through whom he claims shall have annually listed the land for taxation in the proper county for 10 years prior to the commencement of the action if the land is subject to taxation. I charge you that if the period during which the party's deed or color of title has been on record added to the time during which the deeds of color or title of those through whom he claims have been on record amounts to 10 years, he may defend or prosecute on adverse possession. Now I will summarize a little bit for you the law of adverse possession. In order for a person to acquire title to lands by adverse possession, he must prove to the reasonable satisfaction of the jury the following things. First, that he has what is called color of title. Color of title means that a person has a written instrument which purports to convey the title to him, although in fact it may not convey a good title to him. So the first thing that a person must show who claims title by adverse possession is color of title. Next, he must show possession of the land, that is, such possession of the land as the land reasonably admits of, and such possession must be open, it must be notorious, it must be exclusive, it must be hostile against the world, and it must be continued for a period of 10 consecutive years. Now that is the law relative to adverse possession. Now I charge you also that the listing of land annually for taxation in the proper county for 10 years prior to the commencement of the action is just as good as color of title. That is, if a person has possession of land and holds the possession for 10 years openly, notoriously, exclusively, hostilely, and lists the land annually for taxation for 10 consecutive years, then he would acquire title by adverse possession. I charge you that in the law of adverse possession, a person claiming the land may tack onto his possession the possession of those under whom he claims, in order to make out the 10 years that is required by the law. The evidence is for you, gentlemen, to pass upon. I have given you the law relative to prescription and relative to adverse possession, and it is for you to apply the law to the facts in this case and in the rendition of your verdict. You are to pass upon the evidence, and you are the sole persons who can pass upon the evidence. You have watched the witnesses testify. You have seen their manner, and you have listened to them, and it is for you to pass upon their testimony. Now, if you believe that any witness has willfully testified falsely as to any material fact in the case, you can disregard all of that witness's testimony, or you can believe part of it and disregard part of it. Those are matters for you to work out in your sound judgment and discretion in your effort to find out what is the truth in the case. The verdict forms in the case have been drafted to aid you in making up your verdict, whatever it is, whether it be for the plaintiff or the defendants. If you find by your verdict that the plaintiff is entitled to and should have the possession of this disputed land, then you would find the verdict for the plaintiff on the form that has been drafted. If you should not find that the plaintiff is entitled to this land, why, it would be your duty to find a verdict for the defendants. As I have stated to you, the burden of proof is upon the plaintiff in this case to recover upon the strength of her own title and not upon the weaknesses of the title of the defendants. The parties in this case have requested certain written charges. These charges are correct statements of law, and I will read them to you. You are to take them and consider them in connection with the oral charge that I have given you. This literary is called Not All Gas is Created Equal. Isn't gasoline quality pretty much the same regardless of brand? Let's find out. In other words, you're asking if you can cheap out and buy the least expensive stuff with no unfortunate consequences to your car's engine, right? Sorry, but my own anecdotal evidence as well as some convincing research by AAA suggests that the answer is a definite no. After the dreaded check engine light came on in my car last summer, I suffered a near $500 blow to my budget for repairs, plus a scolding from my trusted mechanic because I consistently penny pinched at the gas pump. Though it's no consolation, I'm not the only penurious motorist. A study by AAA found that American motorists are 6 times more likely to choose a gas station based on price rather than on the quality of the fuel. Hence the problem. The combustion process, gasoline and air burned in the cylinders to produce power, also produces byproducts, carbon being the most relevant to this discussion. Carbon deposits inside the engine disturb airflow and air-fuel ratios, adversely affecting performance, emissions, and fuel economy to the point that it might set off the check engine light and trigger the need for potentially expensive repairs. Decades ago, it was routine procedure to partially dismantle engines to remove carbon deposits. The Brits called it decocking. There was also the Italian tune-up, running the engine near red line to burn off carbon deposits. Modern engines are even more sensitive to carbon deposits on such components as intake valves and fuel injectors. These deposits cause a rough, idle, hesitant acceleration and knocking or pinging, among other symptoms. In 1996, the Federal Environmental Protection Agency decreed that gasoline refiners must add detergent to every grade of gasoline, regular, mid-grade, and premium, to prevent carbon buildup. But 8 automakers, Audi, BMW, Fiat Chrysler Automobiles, General Motors, Honda, Mercedes-Benz, Toyota, and Volkswagen, deemed the federally required amount of detergent additive insufficient. They formed an alliance called Top Tier to test and certify that gasoline brands have additional detergent additives to keep their engines performing as they were originally designed. And we will finish that one later. Let's try a little more jury charge. The subject of this jury charge is supervisory responsibility. Ready? As a foreman or supervisor in an industrial plant, you deal directly with a number of people in your everyday work. How well your work gets done depends in large part on how well you get along together. This is just plain common sense. The foreman or supervisor needs to know his subordinates as individuals, people with private lives, with a lifetime of past experience, and a set of aspirations for the future that affect how they behave in the work group. The foreman or supervisor, of course, is a separate and distinct individual too. He has his own personal likes and dislikes, his own private problems and aspirations. As in the case of the workers under him, what happens on the job often has a strong effect on how he behaves with his family and friends after he gets home in the evening. But there is a big difference. The behavior of the foreman or supervisor is likely to be of greater importance to more people than is true of other workers, but the foreman or supervisor, like everyone else, will have personal problems that he will bring to work with him sometimes. If, however, he can recognize and accept the fact that he is feeling angry or upset because of these problems, he then may be able to take responsibility for these feelings and separate them from his attitudes towards his fellow workers. On the other hand, if he is not aware why he is feeling angry or overcritical, He may tend to push his subordinates around. This will make them resentful. Morale will be lowered and production and efficiency will suffer. Besides the difficulties that this kind of situation leads to on the job, these feelings of resentment or insecurity may be carried back into the home after work and may lead to further difficulties in living on the part of the employee. A good worker is a mentally healthy worker. People who are mentally healthy feel comfortable about themselves. They neither underestimate nor overestimate their abilities, and they can accept their own shortcomings. They feel able to deal with most situations that come their way and are not bowled over by disappointments or by their own uncontrolled emotions. They have self-respect and respect for others. The average person expects to get certain basic satisfaction from his work. He wants to feel secure in the job and that he is needed and wanted. The average person wants recognition. He wants to feel that his efforts are appreciated, that his contributions will bring approbation from his supervisor and fellow workers. The foreman or supervisor plays a large part in seeing that things go well, in providing a healthy environment at work. By his attitude, by the way he conducts himself and deals with his men on the job, he determines whether the work group is a smooth running and harmonious unit, all pulling together. And that will conclude our literary and jury charge practice.